Ladies and gentlemen, thank you very much for joining us this afternoon. Warm welcome to Better the Devil You Know. I've lost track of how many times we have run this particular seminar series, but this is the second year that we've had to do it virtually, which saddens me somewhat because I think it's stating obvious to say that we would all much rather be meeting in person. Previous editions of this in person have been done at the Mackenzie Building in Edinburgh. And the great benefit of that is, of course, that we can all have a coffee together beforehand, or if you prefer, a glass of wine afterwards. So whilst there's nothing stopping you from indulging yourself with a glass of something just now, I do look forward to the day when we can all have a bit of a chat, bit of a get together, and a glass of wine or a trip to the pub afterwards. So let me just appreciate it's not terribly professional to do this, but if I look a little bit flustered here, I'm just going to give you an explanation for that. I can tell you that about 20 minutes ago, I was sitting here with a black shirt on, and it occurred to me only when I switched on Zoom that if I stuck with that choice of shirt, I would look just like a floating head. You know, something akin to one of the characters in Red Dwarf, for those of you who are old enough to remember that. So, having averted that possible disaster, I think it's best that I just quickly pass you on to the star attractions. Our panelists today are Nicola Gilchrist from our family law group, and of course Sarah Trainer, who will a week on Friday, when she calls to the bar, join our stable and join, of course, our family law group. So I'll pass you on to that pair shortly. Before I do, just a couple of items of housekeeping, if you wouldn't mind. First of all, I should make everybody aware that this webinar is being recorded. So yes, for the second time today, no swearing, please. And if you wouldn't mind, just as is standard with these sorts of online events, if you wouldn't mind keeping yourself muted and your video off as well, that would be great. There is the chance to chat with us, and if you have any technical issues, then I'd suggest that if you use the chat function for that type of thing, then that would be ideal. If you have a question for either of the panelists, our intention is to deal with those at the end of the talk, and if you wouldn't mind using the question and answer function there, that'll let us filter out what is a Q&A matter and what is a technical issue. So, as I say, the intention is to deal with those towards the end. So, I appreciate that time is tight. I'm well aware that I might not be the only person attending here this afternoon who's interested in Denmark versus Belgium at 5 o'clock. So we'll do our absolute best to keep to time. Yes, we'll see what we can do to make sure we're all finished in time for the football. Anyway, moving on, I'll pass you over now, if you wouldn't mind, to Nicola Gilchrist Advocate. Nicola, over to you.
Thank you very much, Andrew. Hope everyone can hear me okay. Good afternoon. It's great to see so many people here this afternoon. It is my pleasure to introduce today's speaker, Sarah Trainer. Sarah may be known to many of you as a family law practitioner. She is also has a great deal of experience in criminal law, and she has also been my devil this year. And she has, in my own estimation, demonstrated true talent in the field of family law. When working with her this year, I have from time to time been minded of the fabulous film All About Eve. The film buffs amongst you will get what I mean. Google exists for those who don't, but for present purposes, I am quite okay with being cast as Betty Davis in these circumstances. She has been very active in providing her views on the cases that I have, and I think we've had rather a lot of fun over the past year. It is safe to say that I shall very much miss her involvement, but my loss is your gain. And Sarah will be admitted to the bar on Friday, the 25th of June, when she will join Arnott Manderson Advocates. She is going to speak to us today about reduction and variation of minutes of agreement in family law cases. Now, I consider this to be a very interesting topic and something that I have been asked to opine on fairly regularly in recent months. So I'm sure this talk will provide very useful information for the family law practitioners amongst us today. So without further ado, Sarah Traynor.
Thank you very much, Nicola. Hello, everybody. I hope you're doing well from wherever you're listening from. First of all, a massive thank you to Nicola for that introduction to my ever-patient devil mistress. And she's correct, we've had a great year and hopefully many more happy occasions to come. As Andrew, I don't think said, I have prepared the webinar today, but I've also prepared a number of slides which contain quite a lot of information. So I think it will be easier for you perhaps to not be taking notes or anything like that. I will send those to the clerks and they should go out to all of the attendees. So hopefully that will be of some use to you if the subject matter is something which you have a case on or you want to work on later on. So right now I'm going to share my screen, hopefully, if not for the ease of presenting the information, then simply I think because it makes my own picture appear a lot smaller in the corner of your screens. This afternoon, as you will see, and as you signed up to, the topic I have chosen to explore is the enforcement and reduction of written agreements. And as you may have surmised from the synopsis, I intend to explore this primarily in a family law context. I hope that the discussion, particularly of non-matrimonial agreements that I'm about to go into, will be relevant to anyone watching who doesn't primarily practice in family law, but like most legal professionals, I think everybody has to deal with a form of written agreement between parties, and hopefully the things I will go on to discuss will be helpful for that. I hope that this will make you aware of the grounds upon which written agreements can be open to challenge, and if those grounds do exist, then the mechanisms by which we can ask that the agreement can be departed from. By way of introduction, the idea of this topic came up from one of the most recent Sheriff Court judgments, which appears on the Sheriff Court website, which was published. It's an Edinburgh Sheriff Court case, which is anonymised as MC against MM, which is dated the 16th of April of this year, and I will go on to explore that case in further detail later on. But that was a case which involved a written agreement which was prepared and signed during a party's marriage, and one which, when one of the parties went to sign that document, the solicitor who was present during the signing quipped that he was signing his life away, which is the explanation for the name of the webinar today. But more on that later. By way of introduction, I thought it would be helpful to first think about the types of agreement which can be reached in family law cases, because the type of agreement and the time that it was reached can have a bearing on the principles to be applied in considering whether that agreement can be departed from or whether it cannot. Essentially, in family law cases, the distinguishing feature, as it is in many other things, is quite simply marriage, i.e. whether the agreement makes financial provision relative to a divorce or to the dissolution of a civil partnership, as opposed to simply the end of a relationship in general. Now, I suspect throughout the course of this afternoon, I will be saying the words divorce or dissolution a lot. So please, when I say divorce, assume that I also mean the dissolution of a civil partnership. It can be quite a mouthful describing all of them, which, as we know, has the same legal implications. We see that there is an important distinction in law between couples who have chosen to take the legal step of getting married or entering into a civil partnership, or whether they've chosen not to take that legal step. And that is reflected in the nature of the provisions which govern agreements in relation to those.
Sarah,
an agreement.
Sorry to interrupt, it's Andrew here. I don't think we can see your slides just at the moment.
Oh, I apologise. Don't worry, you've not missed much yet. Here we go, that should be them.
Super.
Brilliant. Now, an agreement pertaining to a marriage, as it is detailed there, can be prenuptial, so before the marriage, or postnuptial, which is after the marriage. Both are matrimonial agreements insofar as they're likely to make financial provision on divorce or dissolution. Non-matrimonial agreements, as I'm sure everyone will appreciate, run far and wide, but the most common types in family law cases are, I would say, certainly cohabitation agreements, which, for example, can be entered into when cohabitants purchase a property, or separation agreements for couples who are separating but not married or in a civil partnership, but they have other matters to resolve upon the breakdown of their relationship, be that relating to children, finances, even pets, anything really. It's important to remember that no matter what kind of agreement it is, they must all follow the general principles of the law of contract. So matrimonial agreements are in a separate category, which means they have added considerations, which I'll detail later, but all agreements must follow the general principles. Beginning with the general considerations in relation to agreements, the law of obligations applies. So we're in the territory of contract law here, which might take some of you back. Now, there is a problem with a written agreement which has been signed sometime previously. It's either going to be a party who's seeking to depart from the agreement for whatever reason, or a party seeking to enforce the agreement if it hasn't yet been adhered to. If you are the party who's seeking to depart from the terms of the agreement, then you will require to raise an action for reduction. That can be raised in the Court of Session or the Sheriff Court, and I've detailed the provisions that you'll need to be taken to there if you want to do that. The forum that you choose is very much dependent on the value of the case. If the value is under £100,000, then it must be raised in the Sheriff Court if it's for reduction only. So if that is the only crave that you're seeking. But as a caveat, then the limit does not apply when the proceedings are for divorce or dissolution of a civil partnership, which can always be in either court. So that's an important distinction, again, between matrimonial and non-matrimonial agreements, and whether the action would become part of a divorce or a dissolution or would not. Separately, if you are the party who's holding the minute of agreement, which is not being adhered to, and you want something to happen as a result of that, then you need to enforce it. And how you do that will depend on what it is you're looking to do. If the agreement says you should receive money that you haven't received, then you could raise an action for payment of that money, be it by way of a capital sum or periodical payments. If the agreement is for a property to be sold that hasn't been adhered to, you could raise an action for division and sale, and so on. I've named, I think, on the slide there, specific implement. That is there as a catch-all, effectively to implement the terms of an agreement should any other clearer remedy not be apparent. Turning then first to reduction and the grounds for reduction, you would either want to, of course, enforce or reduce the minute of agreement, but what are the grounds for those remedies? The grounds for enforcement are fairly clear. You've got a signed agreement, of course. It'll be signed by the contracting parties, and that will be binding. And if it hasn't been adhered to, that is the basis you want the order you're seeking from the court. So that is the basis you'll want to enforce the order. Fairly self-explanatory. The grounds for reduction, on the other hand, are, in my view, certainly a lot more nuanced, a lot more technical. Certainly from my perspective, I think some of these terms that you see on the screen just now take me back to first year at university, muddling through contract law and learning these terms and concepts for the first time. Turning first to extortion, that is something which induces an agreement by fear, be that of violence, of threats or force. I think it's fairly clear in that circumstance that a document containing an agreement reached in those circumstances can be reduced if that can be proved. We get a little bit more complicated when it turns to things like fraud. So that is an intentional deception or an intentional misrepresentation. This can be I have found in previous cases particularly relevant in a family law context when a party has failed to disclose something when they're under an obligation to do that. But for reasons I will go on to discuss, I think that circumstance is likely better covered in the provisions which relate to matrimonial agreements rather than anything else, because it tends to be as a consequence of a marriage or a civil partnership that the obligation to disclose finances will arise. The next ground, I think, is the most technical. It's called facility and circumvention and relates to three things. Firstly, the weakness of mind of a party. Secondly, the inequality in a transaction. And thirdly, the inducement to do something by deceit or dishonesty or deception. This is a ground in which there's some significant case law to go through, but unfortunately, of course, today there's not a lot of time to go through all of that, and I want to get on to the matrimonial provisions as well. So if that is something which you're seeking to rely on as a ground for reduction of a document, then that is something which you will need to pay close attention to, and I would encourage you to look at the case law in relation to facility and circumvention. The next ground is undue influence. I think it's a bit more self-explanatory. A dominant party who's gaining an advantage or a benefit over another via the agreement. At this stage, it's perhaps appropriate to raise the issue of legal advice. Of course, if a party has received legal advice in relation to an agreement prior to signing it, then that's relevant when it comes to whether the document can be reduced. But it's not simply the mere fact of legal advice having been tendered or not. It's also important to know whether parties received independent advice and, of course, the nature of that advice. As we all know and presumably will have experience of, it's perfectly possible for a client to seek to come to you for you to simply draft a legal document in the terms that they request, but with no advice in relation to the implications of that agreement, for example. That could be at the extent of your involvement, simply drafting, not providing advice, not providing a view, and that's absolutely fine. But if you're seeking to reduce a document, then it's essential for you to know or find out exactly what advice the party received, if any, prior to the agreement being signed, because that is information which will be highly relevant to the decision maker. And unfortunately, it could involve an awkward conversation with another solicitor inquiring as to exactly what advice was tendered in a particular case. That's an issue that you want to be alive to and have those conversations as quickly as you need to whenever that issue arises. Lastly, moving on to error, I put there in expression or in intention. This is really a ground which is all about clarity. So clarity of language, ultimately clarity of what the parties have decided and signed up to within the agreement. Of course, agreements can have mistakes. They can be confusing, they can be legalistic, they, to be blunt, can be quite badly drafted sometimes. That doesn't mean you have an in terms of reducing it. As a general principle, and as you'll go on to see in the cases that I'm going to discuss, courts are very reluctant to overturn agreements which have been validly entered into. If the general tenor of the agreement is clear and the intention of the parties in entering that agreement is clear, then bad drafting or mistakes are not going to be sufficient for reduction. So error is certainly a ground which I would use with caution. Moving on then from just general principles in relation to contractual agreements and specifically looking to matrimonial agreements. They can have all of the previous considerations, but also have the extra considerations which are in terms of the Section 16 of the Family Law Scotland Act 1985. Firstly, it should be said that Scots law in general allows parties a great deal of freedom in relation to agreeing the terms of their own divorce. So the principles which are set down in Section 9 of the 1985 Act, for example, fair sharing, economic advantage or disadvantage, the burden of childcare, those provisions are not mandatory. Those are the fallback provisions if the agreement cannot be reached. But it's common for parties, of course, to come to a division of assets and other financial provision that doesn't wholly square with those principles. it may make sense in parties' own individual circumstances to negotiate a settlement between themselves that suits their own facts. Every case will turn on its own facts in that regard, and parties can essentially agree what they want, but that comes with the caveat which you can see on your screen at the moment. You'll see section 16 of the 1985 Act makes provision for minutes of agreement, or indeed individual terms of minutes of agreement, to be set aside where the agreement was not fair and reasonable at the time it was entered into. The terms of this provision are limited, of course. They're designed to protect the weaker of the two parties from being compelled to agree to terms which are plainly not in their interests. And it's in terms of this particular section where an application can be made to the court to reduce, or to use the term within that section, to set aside the agreement in part or in whole. An application, as you'll see, can also be made for variation. And it's vital that any application in terms of this section is made before the parties are divorced. The leading case, and the one which effectively sets out the test for setting aside matrimonial agreements, is the 1995 Outer House decision in Gillon against Gillon No. 3, in which a wife sought variations of a minute of agreement she entered into following separation and prior to her divorce. The agreement sought to prevent the wife from claiming a capital sum upon divorce in exchange for other rights which she acquired. And she sought variation on the basis that the exclusion upon her claiming a capital sum was not fair and reasonable, using the legislation terms, because the value of her husband's pension rights was not known at the time the agreement was signed, and that value turned out to be quite significant. And so she thereafter wanted the ability to claim a capital sum so that she wouldn't miss out on the value of that pension, which she wasn't aware of when she signed the minute of agreement. She was aware of its existence, but she wasn't aware of its true value. The court ultimately refused to reduce the minute of agreement, but in doing so, they laid out a set of general principles which are to be applied in these types of cases, and I've detailed them on the slide there. Firstly, the agreement must be examined from the point of view of both fairness and reasonableness. That is what's narrated in the statute, and those are the two key concepts which apply here. Secondly, examination must be of all the relevant circumstances leading up to and prevailing at the time of the agreement, including the nature and quality of any legal advice which was provided. Thirdly, evidence of unfair advantage taken by one party of another may have a cogent bearing on the determination of the issue. Fourthly, the court should not be unduly ready to overturn agreements validly entered into. And lastly, the fact that it transpires that an agreement has led to an unequal division does not necessarily give rise to any inference of unfairness or unreasonableness. The whole circumstances need to be taken into account. You might think, having seen those principles and having been through previous principles in relation to all agreements, that these are not miles away from the general principles in relation to agreements and contracts, which have existed in common law for a very long time indeed. But Gillon, I think, has proved to be the case where in matrimonial agreements, the principles have been laid out very clearly and succinctly. And parties who are considering making an application in terms of section 16, these are the principles which should still be relied upon and should still be referred to in a case of that nature. Moving on to a more recent case in 2018, the case of Bradley against Bradley. In this case, the Sheriff Appeal Court effectively endorsed the approach taken in Gillon and endorsed the 5-stage test that was previously set out. This was a successful appeal which overturned the decision of a sheriff at first instance, who actually chose to set aside the agreement. The agreement itself had all sorts of terms which the husband saw to him to be disadvantageous to him, and that included making monthly payments to his wife from his own pension, and those monthly payments had no limit of time, so they were made or to be made under the terms of the agreement indefinitely until death. He sought to reduce that particular clause in the minute of agreement, and that was at first instance set aside, but the appeal was allowed and the appeal court found that the agreement should stand. And in upholding the agreement, the appeal court agreed that the underlying ethos of the 1985 Act was that of a clean break upon divorce. But they also commented that there is a number of competing principles in the 1985 Act which can't possibly all be considered in cases of this nature. Parties, as I said previously, are able to contract out of some of these principles if they so wish. The parties in this case have chosen to opt out of the clean break aspect of divorce by directing that the monthly payments be made indefinitely until death. That goes, of course, against the clean break ethos of the Act, but that in itself, the appeal court heard, is not necessarily unfair or unreasonable. The statute dictates that in applications under Section 16, it's only for the court to assess unfairness or unreasonableness, and that doesn't have reference to any of the other wider tests or ethos of the Act. And in doing that, in this case, they found that the agreement was not unreasonable or not unfair, so it was not set aside. Turning back to something I've also mentioned previously, in this case, the lack of legal advice was a feature. The court commented that no evidence was led in relation to a causal connection between the husband's lack of legal advice, which was a choice he had made. He had the option to take it and he did not. His decision to agree to the relevant terms was not connected, or the evidence was not led to show that there was a connection between his decision to sign the minute of agreement and the lack of legal advice that he received. So here, a lack of legal advice was not a barrier to the agreement being enforceable. The appeal court, in handing down their decision, also provided a list of evidential requirements in cases of this nature. So Gillon set out the test, and here we have a set of evidential requirements which the court deems it to be relevant and to be considered in cases of this type. Firstly, the party seeking reduction must aver the practical, financial, or other consequences of the existing arrangement. So what does the agreement say? What does that mean for parties practically speaking? Does it mean they have to sell a property? Does it mean they'll have to make monthly payments? What actually happens in terms of the agreement? Secondly, they must explore why that consequence is unfair or unreasonable at the time the agreement was entered into. Will it leave them out of pocket? Does it significantly advantage another party to their detriment? What does it mean to them, and why is that unfair or unreasonable at the time it was entered into? They must also lead evidence on whether there's any offsetting to take into account. So, for example, are there any other factors at play which could render a clause which might look unfair upon the face of it to then actually be quite reasonable if there's other matters to be taken into account? And finally, they must detail what specifically would be the minimum intervention required here to alleviate any unfairness or unreasonableness as at the date of separation, having regard to the effect on both parties. So this effectively is the information that the court will want from you if you are making an application in terms of Section 16. Moving forward in time now, and getting to the most recent case on this issue, and the one that I referenced earlier, that of MC against MM. This case, if anybody has had a read of it, I'm sure they will agree it has a lot of quite interesting and memorable elements, one of which is that the parties were young retirees from NASA who had come to live in Edinburgh to take a break from their careers. But it's also the only one of the three cases which I'm going to talk about today in which ultimately the agreement was wholly set aside. In Bradley, of course, the appeal court held the agreement was fair and reasonable, and similarly in Gillon, that was held. This action was raised by the wife who sought divorce and enforcement of an agreement which was entered into during marriage, and that enforcement was sought by way of payment of a capital sum, which she was entitled to in terms of the minute of agreement that had previously been entered into. The defender, the husband, then sought for the agreement to be set aside, and so a proof took place in relation to that matter. The agreement was signed in circumstances where the husband was seeking to prove his loyalty and his love to his wife, and the sheriff held that the agreement, which was signed only a matter of months before separation, clearly intended a very unequal distribution of assets. I think the pursuer in this case was to receive £750,000, and the defender only set to receive £50,000. So effectively 6% of the matrimonial property, when it was agreed at proof that both parties had contributed equally to that wealth. And so it was a very stark and very unequal distribution of the assets which had previously been agreed. The sheriff found that a variety of circumstances existed which justified the setting aside of the agreement. First of all, the terms of the agreement were found to be manifestly unfair because the split of the matrimonial property was so stark. Those figures, I think you'll agree, are quite dramatic. She also held that the defender was in a subservient position and was somebody who was at risk of manipulation. A psychiatrist at the proof gave evidence that the defender met the criteria for severe depressive disorder and that he had sought counselling at the time the agreement was signed. Further evidence was also led, I think, that the pursuer took advantage of the defender, that the nature of the relationship was one which the sheriff found or deemed to be controlling and abusive. And the agreement is a document which was rushed through with no legal advice of any substance. Although a solicitor did draw up the agreement, he was not asked for, and I did not provide any advice in relation to its legal consequences. And particularly, he didn't provide any advice in relation to whether it could be said that the agreement was fair and was reasonable at the time that it was entered into. And indeed, as I referred to previously, the solicitor who was present when the defender signed the agreement commented that he was signing his life away. She gave evidence to that effect at proof, and that was clearly a matter which played on the sheriff's mind in reaching her decision. I think it's fair to say that going through the facts of that case, they're fairly extreme. There is a bit of everything which might give rise to a challenge there. But one thing I found when exploring these cases quite closely is there isn't a great deal of clarity in relation to the exact order that you should be seeking. In Gillon, the wife wanted to claim a capital sum. That option was not open to her because she had signed away that option under the minute of agreement. So she sought to vary that particular term to allow her to then make that claim. In Bradley, the husband sought reduction, but only of certain terms of the agreement. The terms, of course, which were disadvantageous to him. So particularly the term which dictated he must make monthly payments indefinitely until death. He didn't seek to reduce the entire agreement, only parts of it. And then laterally in M against M, the wife sought to enforce the agreement and the husband sought to set the whole agreement aside. In my mind, variation, reduction, setting aside, enforcement as well, these are different remedies. So which one is right? What do you need to put into your pleadings effectively to get the order that you want? Well, rather predictably, and as certainly I found to be the answer to be most things in family law, I think it really depends on the case. So as long as you're clear as to what you want to achieve and you make reference to section 16 as the basis for doing that, then that should be sufficient to let the court and to let other parties to the action know what you're seeking in your craves and conclusions and the basis upon which you're seeking it. Turning to giving advice on agreements, I certainly think that knowledge of these cases and these principles greatly assists when, not only when you want to enforce or reduce minutes of agreement, but also when you're asked to draft or advise on agreements generally. I thought it would be helpful to outline what you should and shouldn't be doing when a client comes to you regarding an agreement, not necessarily to reduce or enforce that, but just simply giving general advice in terms of agreements, because that's something which I'm sure we all do quite frequently. First of all, the most simple thing is you can't act for both parties. That will very likely be a conflict of interest, and that is prevented by the rules of the Law Society of Scotland. But as we've seen from the cases, independent advice is not a requirement. So if you act for a party and the opposing party is choosing for whatever reason not to obtain or follow legal advice, that is a choice which is available to them. It doesn't prevent the agreement from being reached. And as we've seen, it doesn't necessarily bring it open to challenge. As long as the opportunity to take advice was available to them and they chose not to avail themselves of that opportunity, that's a matter for them. Also, full disclosure is not a requirement in an agreement in Scotland. What I would say is, if you're acting in a matrimonial matter where there has not been full disclosure, and that is a choice that parties have made for reasons of time, for reasons of cost, put it in the agreement, because that way everybody is clear about what information has or has not been made available in the course of negotiations and what parties are aware of when they're signing something. The last thing you want is somebody to come back saying, I didn't know X, and that is exactly what they had signed up to. Their knowledge of X was something they knew at the time. I think if there's anything the most recent case I referred to proves, it's that the timing is important to consider in all of these cases. If one party is not in the right frame of mind, if things are being rushed through, if there appears to be an inequality of power or an imbalance at play, if one party is unwell or is suffering with difficulties with their mental health, take a step back, slow things down and ascertain, is this the right time for the agreement to be reached? And if the agreement is reached and the documents are signed at this time, might that be raised as an issue later on down the line? It's just something to bear in mind. Of course, I'm sure pressure from clients to get things done quite quickly, get things done at the right time is overwhelming, but it's something certainly to consider based on the time of signing can have such a bearing on whether the document is capable of being reduced or not. Registration is preservation, and as legal professionals, we are naturally, I think, very keen to register any official documents so that they can be preserved, because you never know when they might be needed, and guaranteed when you need them, they won't easily be available. So registering them preserves them for future use, and they're always readily available should it be required. And I think that's entirely the right approach. But parties might draft their own agreements. They might not register them. They might not see that as a step which they need to take, or they might not even know it's a step that's available to them. So in that circumstance, it's important to bear in mind that what they have signed is still binding upon them and it can still be enforced. They've still signed a contract. And the last consideration, which I've narrated, is the consideration of third parties, particularly in matrimonial cases or cases which involve children. Parties might be inclined to involve others within the agreement. For example, they may have taken a loan from parents, which requires to be paid back in instalments. They may provide for a property or for a sum of money to be paid over to children. Bear in mind that those people will have a remedy of enforcement in the future too. In particular, children, they might not benefit from for years to come, and parties' financial circumstances could be vastly different some years down the line. So ensure that parties are aware, even though it's far in the future, it's still a legally binding agreement. And if they've signed up to it, it's something that someone can enforce against them later on down the line. Lastly, and to round up, you should see a dispute checklist. These are things which I certainly have found it helpful to consider when approaching a matter which it involves an agreement that needs something done with it. So whether that be enforcement, whether that be reduction or setting aside. Firstly, and as we spoke about at the beginning, ascertain what type of agreement it is. Is it matrimonial? Is it not? Does Section 16 apply to it, or does it not? Secondly, are there time limits running? I'm thinking particularly there in terms of Section 28, which might send shudders down a few spines, but In a circumstance where there is an agreement you're looking to reduce or enforce that ties in with a potential Section 28 claim your client may have, you need to be acutely aware of that and ensure you don't miss the time bar. Because if it's coming close and you're not quite sure what's happening with the agreement, you're still disputing the terms of the agreement, then it's important that you raise your time barring claim in order to protect your client's position. And you can always have the two matters running at the same time. Thirdly, and as in every case, consider whether it can be resolved. In the M against M case, the figures were stark. There was a £700,000 difference. So resolution was less clear of a practical solution than probably it would have been in many cases. But if the figures are closer together, you need to consider whether it's worth litigating the terms of the agreement. Also with reference to the sort of evidence that you'll need to lead and the time and the expense that might incur. Does your client want to buy the risk of losing by coming to a settlement, or are they quite confident in their position and would they rather take the matter to proof and take their chances? It might be a cheaper option for them to settle. So it's always something to be considered. Fourthly, what orders do you need from the court? This has to be considered on a case-by-case basis. And the only thing, I think, the only golden rule is to just make sure what you're seeking is clear and you know exactly what you want. Be that setting aside or variation or reduction or enforcement. Be clear as to what you want to happen as a result of the document. Fifthly, are there any other documents which are impacted by or relevant to the agreement? I'm thinking here, for example, about an agreement which a party requires to transfer a title on a property. If that has been implemented, then there will be a disposition to that effect. And that disposition is a legal document. So that will also need to be reduced if that's been affected. So considering other documents which might form part of the process is essential, because they too might have to be included in the action. And then lastly, and most broadly, what information is relevant to the decision maker? You will need to request, collate, lodge, take recognitions, affidavits, find an appropriate expert if that is going to be necessary. The sooner you identify all of the information that you will need, the better in terms of getting prepared and ensuring that the court has all of the information that's needed to find in your favour. And the previous cases lay out perfect principles as to exactly what will be needed and at what stage it's going to be needed. So with reference to them, hopefully that will give you a guide as to the types of information that you'll need to collate in terms of your case. So that is hopefully a handy checklist to refer to back if ever any of this crosses your desks in the future. I think that's everything I wish to say on the matter, but we now I think have some time for questions. I've not checked the box, but I wonder if there are any questions.
There are no questions open just at the moment, as far as I can see, Sarah. I don't know what to read into that. That might just be an indication that there are many more football fans amongst the group of delegates than we had counted for. But yes, I don't know. Nicola, do you have anything? You're on mute.
Yes, I know I'm on mute, yes. No, I thought that was a very, very comprehensive presentation about the whole issue here. I have no questions at all. I wonder if anyone else does. Think we have any?
We did have
a good sign.
Other than, yeah, we can't see your slides.
We did have a question emailed in just before the talk started, but it was quite
oh, hang on, we've got one
question, which we'll deal with separately. But
yes, Andrew, could you read the question out that's just come in from Kirsty?
There's Mac. Sorry, yes, here are. I wonder what your position would be where a clause within the minute of agreement with provision to the children who are not party to the agreement need to be enforced.
Yeah, thanks, Kirsty. That is actually something which we have come up with quite recently. Third parties can enforce their own rights under a minute of agreement. So, as I said, I mean, for children in particular, that can be something which can come up a lot later than a party would have envisaged. For example, children who are quite young being involved in a separation, and then them 20 years later turning 21 and being due a sum of money or property or something like that. And they do have a right to enforce that. Now, of course, in a family circumstance, it will depend on the dynamic as to whether they want to do that or not. But if they do, then they can. And that is something to bear in mind when advising parties, because I'm not quite sure that people appreciate the financial implications, or their financial situation can change quite significantly in a very short period of time. So that is certainly something which is possible. It's certainly something which we've seen happen recently, and is something definitely to be aware of if you have somebody who is seeking to involve a third party in the terms of their agreement. I don't know if Nicola's got any comments.
No, the only thing I would comment on, I'm sorry, Sarah, is I think Kirsty was asking if the children were not parties to the agreement.
Oh, right, okay. Sorry, I can't see the question.
No, that's fine. But yes, obviously you've given a very, very good view there. But what about them not being party? I suppose that's just the flip side of what you previously said.
Yeah, I mean, if they're not named and somebody's not going to benefit, then of course they don't have a right of enforcement. But if somebody is named in an agreement as a beneficiary to an obligation, then
yes. Okay. Any other questions from anyone?
I have a very nice compliment from Nairi, but no. Oh, hold on. Here's
there's another one.
Beverly Johnson has a question here, which is as follows. Some degree of depression or mental fragility is pretty normal in family law cases. What would you suggest if a deal seems to be on the table, but one party still seems to be struggling?
I mean, I completely agree. It is a very difficult line to cross and to tread, and I'm sure everybody will have had situations where it's pretty difficult to decide whether somebody is in the right frame of mind to be doing something, and whether it would be of benefit to them to just resolve the matter and hopefully move on. If it's something you're really concerned about, then of course medical information should be available. If they're seeking help specifically from psychiatrists or doctors or independent professionals, then getting their view on the matter might be of some assistance. But of course, I mean, in all family cases, naturally, emotions are going to be running high, and it's just something I think which we all need to be aware of and be able to use our judgment of. Nicola, you probably have a much more nuanced view.
I think what you've said there is very, very, very well stated. Yes, there are certain situations where the psychologist or therapist is worthy of being used, but largely in most situations, I think, as you say, Sarah, they're all struggling. Yes. Anything else?
Anyone else?
No. Well, to that end, may I thank Sarah very much for her talk today, which I think was very illuminating and very helpful to family law practitioners up and down the country in terms of this very difficult issue that I think we're all dealing with. Andrew, can I pass on to you?
Nothing further really for me to say, other than once again to thank you for your attendance today. It's impressive. The event was sold out, and it's pleasing. In fact, I suppose the real benefit of this platform is that we can indeed have people attending from the length and breadth of the country. So I'm grateful to you all. I do look forward, as I said earlier, to the time when we can perhaps get together and be a bit more social about things. But in the meantime, on behalf of Nicola, on behalf of Sarah, and indeed everyone at Arnott Manderson, thank you again for your time and for your interest. In due course, the event will go up on YouTube, and you can rewatch if you're interested, if there's anything you missed. And as Sarah touched on, the slides that she's prepared will be emailed out to all the delegates in due course, so that you have those and can refer to them in your own good time. So yes, as I say, once again, thank you so much for your time. I hope everybody remains safe and well. And as I say, that we can all catch up and be a bit more social sooner rather than later. So thanks to the panelists, thanks to you guys, and see you soon.
Great. Thank you very much.
Good night, everyone. Best wishes.